If you're a naturalized U.S. citizen, there's a good chance that in the last few weeks you've seen headlines or social media posts suggesting that U.S. citizenship is no longer safe. Some posts even claim that thousands of citizens are about to lose their status. Others hint that some new policy has quietly changed everything overnight. For immigrants who spent years navigating the legal system to finally become citizens, this kind of talk cuts deep. Citizenship means stability, belonging, and security. So when it even appears to be under threat, worry spreads very quickly. The problem is that fear spreads much faster than facts, and right now, fear is doing most of the talking. To understand what is actually happening, you have to separate three things: political noise, media framing, and legal reality. These often get blended together online, but in practice they work very differently. Legally, the foundation is very clear. Once U.S. citizenship is granted through naturalization, it is not conditional, it does not expire, it is not reviewed every year, and it does not get canceled just because political priorities shift. The only way citizenship can be taken away is through a formal legal process called denaturalization. And that process is far more limited and cautious than most people realize. Denaturalization is not something new. It has existed for decades and has been used sparingly under both Republican and Democratic administrations. The core idea is simple. If citizenship was obtained through serious, intentional fraud that was central to getting the application approved, the government can ask a federal court to revoke it. That last part is critical. This is not an internal agency decision. It is not an immigration officer pressing a button. It is not something an automated system can trigger on its own. Denaturalization cases are filed in federal court, argued by Department of Justice lawyers, and decided by federal judges. That alone places a natural, practical limit on how many cases can ever move forward at once. Still, recent headlines have fixated on one dramatic claim: that denaturalization cases have risen by as much as 16,000%. At first glance, that sounds like a massive surge and a radical policy shift, but numbers pulled out of context can be extremely misleading. For many years, the number of denaturalization cases filed each year was extremely low, sometimes fewer than 10 nationwide. When your starting point is that small, even a relatively modest increase looks huge in percentage terms. Going from around 10 cases to a few hundred creates a percentage jump that looks terrifying, even though the absolute number is still tiny compared to the overall population. There are over 25 million naturalized citizens in the United States. Even at the highest recent filing levels, denaturalization affects only a fraction of those people. Statistically, for the average citizen, the risk is essentially negligible. But statistics don't drive clicks. Big percentages and scary headlines do. Another piece that often gets left out is how selective the government has to be about which cases it pursues. The Department of Justice does not have unlimited investigators, attorneys, and court time. Every denaturalization case requires a serious amount of work: investigating, locating old records, gathering documents, interviewing witnesses, and building a case around events that may have happened like 10, 15, or even 20 years ago. All of that takes time, money, and specialized legal resources. Because of this, prosecutors tend to focus only on cases where the evidence is strong, the alleged fraud is clear and serious, and the legal theory has a good chance of surviving in court. Close calls and weak cases are usually never filed. There is also a widespread misunderstanding about what fraud actually means in this context. Fraud does not mean an honest mistake. It does not mean you misunderstood a question. It does not mean you followed bad advice from someone who didn't know what they were doing. Fraud here means intentionally lying or hiding information that would have changed the decision on your case. Examples include not disclosing a serious violent crime, hiding participation in persecution or terrorism, or completely fabricating an asylum story. These are the kinds of facts courts see as material. Without the lie, citizenship would not have been granted. That direct cause and effect relationship is essential. On the other hand, minor inconsistencies, old traffic tickets, or small administrative errors do not meet this standard. Courts have repeatedly rejected attempts to revoke citizenship over technicalities or harmless omissions. The legal system recognizes that immigration processes are complicated and that people make honest mistakes. It's also important to understand that even when a denaturalization case is filed, the government does not automatically win. The burden of proof is on the government. Prosecutors must show that a false statement was made, that it was intentional, that it was material, and that it actually affected the outcome. Defense attorneys can challenge the evidence, cross-examine witnesses, and argue that the alleged misrepresentation wasn't decisive. Federal judges approach these cases very carefully. Citizenship is treated as a fundamental right, and courts are extremely reluctant to strip it away without overwhelming justification. That caution isn't a loophole, it is a built-in safeguard. Another common misconception is that denaturalization automatically leads to deportation. In reality, these are separate legal processes. Even if citizenship is revoked, the government still has to go through additional removal proceedings with their own rules, standards, and opportunities for defense. One does not instantly trigger the other. So why does the public conversation feel so urgent, intense, and frightening right now? Politics is a big part of the answer. Immigration remains one of the most divisive issues in the country. Strong, dramatic language excites political bases, even when it oversimplifies or distorts what is actually happening. Media outlets, especially online, often amplify that language because it generates engagement, shares, and ad revenue. Social media makes this even worse. Complex legal processes get squeezed into short clips, bold captions, and emotional soundbites. Nuance and context usually disappear. The result is that many people walk away with the impression that something sudden and dangerous is happening behind closed doors, even when the legal framework is basically the same as it has been for years. None of this means you should ignore the topic. Being informed is always wise. Understanding how the law really works gives you power, but panic does not help anyone. If you are a naturalized citizen and you know there were serious problems or potential misrepresentations in your past immigration history, it is reasonable to speak with a qualified immigration attorney. That does not mean you are automatically in trouble. It simply means you are choosing to be informed about your situation. For everyone else, there is no evidence that ordinary naturalized citizens are being targeted in any broad or routine way. Citizenship is not being quietly dismantled. It is not being mass reviewed. And it is not being revoked based on whoever happens to be in office at the moment. The reality is that the system is slower, more constrained, and more cautious than the headlines suggest. In moments like this, the most important thing you can do is slow down, check your sources, and resist the pressure to react purely on emotion. Law runs on evidence, procedures, and precedent, not on viral posts. Understanding that difference doesn't just calm fear, it puts you back in control of how you respond.